Hey guys, Brooke here with Legal Talk Tuesday, and I am here by myself today. Laura is on a much deserved and needed vacation. Also, I've been having some weird internet issues, so I apologize in advance if I cut out. But today we are going to talk about contracts. More business law, but this is really applicable to any contracts that you enter into. And so I'm going to have a little bit of something for everybody. But we are talking about the enforceability of your contract. Is the contract that you have or that you're entering into enforceable? So I've talked about this topic a little bit before from a different angle. I talked about just kind of the basics, what you need to have in your contract for it to be enforceable, an offer, an acceptance, some kind of exchange, different terms. But today I want to talk about reasons that a court would actually throw out a contract so that you can make sure that you're protected and that you're entering into the contract and that it's enforceable, because otherwise it's a waste of your time and money, and also could result in very bad consequences for you, whether it's your business or some kind of personal endeavor. But the first thing is lack of capacity. So, but that capacity is a mental ability to enter into the contract. That's really important. There are a few different ways that you can lack capacity. The first one is being a minor. So minors under the legal age of 18 cannot enter into a contract on their own. So whatever that is, buying a car, I've heard of that happening before, where minors have tried to buy a car and not been able to be enforceable because of that. But minors cannot enter into their own contracts. Also, incompetency. And so by incompetency, what I mean is mental disability, whether that's kind of a lower IQ or some kind of disease, whether it's something you're born with or later in life, dementia, things like that. Typically, when you have a lack of competency, you are declared incompetent by a doctor. If a contract is ever challenged, generally they like to see that the doctor has actually declared that person incompetent, but you can prove incompetency. Another way that you can lack capacity is if you are under the influence. So if you are entering into contract with someone who is obviously under the influence of drugs or alcohol, that can be challenged. So you want to make sure that the person is fully competent when you're entering into a contract with them. The second thing is duress or undue influence. So both parties of a contract need to enter into that contract on their own free will. No one can be forced to actually sign the contract. So for instance, a person can't be forced into a contract by threat or violence. Usually duress kind of involves, or undue influence kind of involves difference in power or influence between individuals. So for business sake, for instance, a boss requiring an employee to sign something that benefits the boss could be considered duress or undue influence, depending what it is. I mean, if everyone equally has to sign a confidentiality contract, that's most likely going to be found to be okay, even if that confidentiality contract benefits the boss by protecting their brand or whatever. But it may be difficult to prove duress or undue influence. It's not impossible, but it is somewhat difficult. And a more common example when you think of duress or undue influence that we see is when someone is making a will, especially if you have maybe an elderly parent that, kind of relies on a child to take care of them. If they're making a will, that child, maybe sits to inherit certain things or influences that parent, especially if you see something where there are multiple children and one child may be the primary caregiver for the parent or may have more influence over the parent, and the parent drafts something that's totally out of whack that, basically disinherits another child for really no reason. Those are things that the court really is going to look at for duress or undue influence. The third thing is misrepresentation or fraud. So it's really an intentional act to harm or deprive somebody of their right within the contract. So fraud is always misrepresentation. Misrepresentation is not always fraud. Fraud is really the deception of a material part of the contract. And by that, When I say material part of a contract, what I'm referring to is something that's really important and instrumental, not, the wrong date or a misspelled name, something that materially affects the contract. That can be telling a lie, not necessarily telling the whole truth or disclosing things. Misrepresentation, on the other hand, is an untrue statement, fact that's going to induce someone to enter into that contract. So if you can prove that because they relied on that actual fact, whatever they told you, to enter into that contract, then you can prove misrepresentation, but you have to show that you have actually relied on that to enter into the contract. So that can be, say you're selling a business and you misrepresent the debt that you have or the amount of income that you've been making. That is a material component that could influence whether someone wants to purchase that business or not. And so you want to make sure that you don't misrepresent, whether that's intentionally or not, in your contract. Also, illegal contracts are not enforceable. So, I feel like you don't have to say it, but sometimes I feel like I have to say it when I hear things. But if there's something that is against a law or a contract that you're trying to enter into that's against some kind of public policy or regulations, for instance, you can't, in the state of Arkansas, you can't go and enter into a contract to buy or sell drugs. That would be an illegal contract and it's unenforceable. Again, I feel like it goes without saying, but sometimes I feel like we have to say things. Also, an unwritten contract is, it's not always unenforceable. So generally an oral contract is acceptable in a lot of situations if you can prove that contract was entered into, and there are different ways that you can do that. But some contracts are actually legally required to be in writing. So if you are entering into a prenuptial agreement, you can't just say when you're going through a divorce, oh, we agreed to this beforehand, and this is mine and this is hers, and she won't take any of this. That has to be in writing. Contracts for real estate, real property, you need those to be in writing. Sometimes contracts for multi-year services are going to be required to be in writing. So it varies by state. So what I'm saying necessarily for Arkansas doesn't always apply everywhere else. But you really want to make sure that you know what needs to be in writing and what doesn't. So do mistakes make a contract unenforceable? So there are two types of mistakes. One is a unilateral mistake that is just made by one person, one of the parties to the contract, and the other is a mutual mistake, which is something that both parties make when they're entering into the contract. So this is more, when these things come to court, they are considered more on a case-by-case basis. So part of that consideration is going to include whether or not it's a significant mistake. Again, small mistakes, things that don't really materially affect the contract, are not going to be considered significant. Also, you're going to have considered whether or not it results in undue influence, whether it's actually a misrepresentation rather than a mistake. So those types of things are going to be considered if there's a mistake in the contract. But generally, if you have some kind of small mistake, that's not going to be something you're going to want to pursue if it's not going to materially affect the contract. But what I get asked a lot is, okay, thank you for all of this advice. Do I actually need an attorney to draft a contract, to review a contract, whatever? Because, we all know you can Google something online and maybe type it up, pull things from there and create your own contracts. But, and I'm not just saying this is because I'm an attorney. I will tell you a lot of things when we talk to people. If you don't need an attorney, I will tell you do not need an attorney. If you need less help from an attorney and you can do things for yourself, I will tell you that as well. But it's always really good to have an attorney involved in the making of a contract. And that's not necessarily drafting it. If you are competent enough and you have a contract in place, it's a good idea to at least have an attorney review it to avoid, obvious mistakes, and also make sure that the language of the contract is really clear and complete, because as attorneys, we're trained in finding those things, really thinking ahead, thinking of all worst case scenarios, and really making sure that you're protected. When we enter into contracts, these contracts are usually really important. They're, about our businesses, sometimes decisions about our lives. So you want to make sure that you really understand what you're writing. There are certain things by statute that are required to be included in contracts. So an attorney can kind of help you navigate that, whether they're drafting it for you completely or just reviewing it and giving you feedback. So thanks for joining today on Legal Talk Tuesday. We'll be here next week at 11:30, and Laura will be back with us. So thanks so much for joining us, and have a great week.